Welcome back to a new post today, and another victory for a parliamentary democracy, especially with regard to the immunities enjoyed by the members of parliament and the MLAs as well. Supreme Court has said that the MLAs and the MPs cannot enjoy immunity if they take a vote or a bribe. If they take a bribe to vote in the House, whether it is a member of parliament or an MLA. And we all know that there is the member of parliament and the MLAs enjoy certain immunities while they function in this representative body, that is the Legislative Assembly and the Lok Sabha. And many of the decisions in the House is taken based on voting. So many a times we might have heard a cash for votes, or where people take a cash for voting on a particular issue. And recently, even the Trinamool Congress MP Mahua Moitra, she was also accused in asking questions based on taking of bribe from a company with regard to Adani related questions. We had come across that issue itself, and now Supreme Court coming up with its verdict saying that the member of parliament is not immune if they take a bribe to give a specific vote or speak in the parliament or a state assembly is a victory. Now this is a turnover, or it's a total flip on the own verdict of the Supreme Court. A 5-judge bench had given a verdict in the JMM case, where the Supreme Court said that the member of parliament and an MLA is immune from any conviction with regard to a vote or anything spoken on the floor of the House, even if there is an accusation of a bribe taking or money with regard to that. Let's see how the Supreme Court now has changed over the previous verdict and said that it had itself erred in the previous verdict and wanted to correct itself. So the 7-judge bench declared that the parliamentary privilege or immunity will not protect the legislatures who take bribe to votes or speak in the parliament or the state legislative assemblies, and they will not be immune from criminal prosecution. That means they can be convicted for criminal prosecution for taking bribes to vote or speak in the parliament. Corruption or bribery of the members of the legislatures erode the foundation of the Indian parliamentary democracy, and this is what the 7-judge bench headed by our very own Chief Justice of India, D.Y. Chandrachud, said. Now this unanimous verdict authored by Chandrachud overruled a 25-year-old majority view of the Supreme Court in a 5-judge bench JMM bribery case in 1998 during P.V. Narasimha Rao's term, and that the Supreme Court said lawmakers who took bribes were immune from prosecution for corruption if they go ahead and vote and speak in the House as agreed. So this was what was said in the JMM case. The 7-judge bench now this time said that the majority of the 5-judge bench in the JMM bribery case had erred, or it made a mistake. So the court did not want to perpetuate this grave error and wanted to correct its mistake this time. Representative democracy is at stake. This is what Chandrachud said. Chief Justice of India clarified that the offence of bribery was complete the moment the corruption money was accepted by the representative, that is the MLA or the MP, and the culpability of the legislature did not depend whether he actually delivered for the bribe giver on the floor of the House. So the moment the money was accepted, it is called as a corruption act and an offence. The legislature therefore will face criminal prosecution whether or not he makes a speech or votes in favor of the bribe giver. The offence of bribery is complete on the acceptance of money or on the agreement of accepting the money also. So he does not have to have the physical money in hand, but even if the MP or the MLA agrees to accept the money, it is a it comes under criminal prosecution. Chief Justice reasoned that the freedom of speech and expression, which included voting in the House and attendant immunities granted to the legislatures under Article 105 and 194, did not extend to giving or taking of bribes. So though we have immunity from any court on the basis of what vote or what the MPs or the MLAs said on the floor of the House under Article 105 and 194, this does not include taking of bribes, and this is what the Supreme Court said. The judgment said that parliamentary immunity would kick in only if the legislatures act in furtherance of fertilizing a deliberate, critical or responsive democracy. The shield of immunity and parliamentary privilege privilege would be claimed in two circumstances, and that I will be just telling you. So the reference now in this case came from an appeal filed by the JMM leader Sita Soren, who was accused of taking a bribe to vote for a particular candidate in the Rajya Sabha elections of 2012. Though she later denied culpability on the ground that she voted for the official nominee of her own party, the CBI filed a charge sheet in this case on her, and the Jharkhand High Court had actually refused to squash the charge sheet, and now she's coming tapping the doors of the Supreme Court. So this is being said in the Sita Soren case. Now Sita Soren is the daughter-in-law of the JMM chief and the former Union Minister Shibu Soren, who was involved in the alleged JMM bribery case in 1998. And now in 1993, 4 Jharkhand Mukti Morcha MLAs and 8 other MPs are allegedly bribed to ensure the survival of the then PV Narasimha Rao government during a no confidence motion. They voted accordingly, and when the scandal broke out, they claimed immunity for criminal prosecution because their act of voting happened inside the parliament. In 1998, in a majority verdict in the JMM bribery case, the apex court had held that the bribed legislatures were immune from prosecution provided that they go ahead and perform their legislative function of casting their votes or giving their speeches. So what exactly, let's have a few points about much more detail about what exactly the Supreme Court said. Now the Supreme Court, as I told you, there are two articles, there are two articles in the Constitution that speak about the immunity of the MPs and MLAs of whatever vote or whatever they say on the floor of the House, and this is Article 105 and 194 of the Indian Constitution. Article 105 of the Indian Constitution confers MPs the immunity from prosecution in anything said or any vote given in the Parliament or any parliamentary committee as well. And similarly, Article 194 Clause 2 grants the immunity to the MLAs. So the 7-judge bench headed by Chandrachud unanimously overruled the 1998 in the famous JMM PV Narasimha Rao versus the state and opened the doors for the law enforcement agencies, therefore to initiate the prosecution against the legislatures in the bribery cases under the Prevention of Corruption Act of 1988. Now Sita Soren, I told you, I already just now explained the case about Sita Soren accepting the bribe to cast her vote in favor of a candidate in the Rajya Sabha elections of 2012 and how she is coming now to the Supreme Court. So in 2014, a 2-judge bench referred the matter to a 3-judge bench. In 2019, a 3-judge bench headed by Chief Justice of India Ranjan Gogoi noted that the decision in the PV Narasimha Rao versus the state dealt directly with the case. Considering that the case has decided by a narrow margin of 3:2, it was referred to a larger bench, underscoring that the issue is of substantial and general public importance. Now in September 2023, a 5-judge bench headed by Chandrachud doubted the correctness of the majority view given in the PV Narasimha Rao case and accordingly referred the matter to a 7-judge bench, which has given the verdict yesterday. While recognizing that it is very important as an issue for our polity, the bench added that the objective of parliamentary privileges is not to set apart the members of the legislatures as persons who wield higher privileges in terms of immunity from the application of general criminal law of the land. So they are not immune just because they are MPs or MLAs, and definitely they come under criminal prosecution if they do something wrong that is involved in corruption for anything to be set and vote be given in the parliament or the state legislature. So what was the 1998 ruling that is being reconsidered? Now in the PV Narasimha Rao ruling involves the 1993 JMM bribery case involving the JMM chief and the former Union Minister Shibu Soren and the father-in-law of Sita Soren, the petitioner in the present case. Soren, along with some of his party members who were accused of taking bribes to vote against the no confidence motion against the then PV Narasimha Rao government. The 2 judges of the Constitution bench opined that the immunity granted under Article 105 Clause 2 and Article 194 Clause 2 could not be extended to cases concerning bribery allegations for making a speech or any voting on the floor of the House. On the other hand, the majority of the judges observed that although they were acutely conscious of the seriousness of the offence, since the sense of indignation should not lead to a narrow construction of constitutional provisions, as this may result in impairment of guarantee or parliamentary participation and debate. So what are some of the big takeaways in this verdict are as follows. The first takeaway in this verdict, which you need to remember, is that the Supreme Court said that there is no violation of the doctrine of stare decisis. Now this is a legal principle that obligates the judges to adhere to a prior verdict where the ruling is on a similar case, and the similar case to this is the JMM case of 1998. Now the judgment, it is also called as a PV Narasimha Rao case, which granted immunity from prosecution to the members of the legislature who are allegedly engaged in bribery for casting of their vote or speaking, and the court said that the Supreme Court had erred in that case, and therefore they wanted to correct the mistake that the Supreme Court had done in that case, because it affects the parliamentary democracy and also the conscience of the parliamentary working system as well. Number 2, legislative privileges have to conform with constitutional parameters. Such rights in India have always flown from the statute or from the constitution, and therefore after independence became a constitutional privilege under Article 105 and 104. Therefore, whether a claim is a privilege in case it has a privilege or no, this has to be tested on the basis of the parameters included in the constitution, that is Article 105 and 195, and this is subject to judicial review. This is what the Supreme Court said. Constitutional immunity from the bribery charges does have to fulfill a two-fold test. This is what the Supreme Court said. Now the two-fold test, that is a shield of immunity or parliamentary privileges, could be claimed under two circumstances. This is what the Supreme Court said today. One is that if the actions of the legislature were meant to enhance the dignity and the authority of the House and its members as a collective body, and secondly, if they were in exercise of its rights to free speech, protest and freedom of arrest and others. A claim from immunity would not survive if it failed the two-fold test. This is what the Supreme Court said. And finally, bribery is not immune just because it is essential to the way a vote is cast. So clause 2 of Article 105 has two limbs. The first prescribes that the member of the parliament shall not be liable before any court in respect of anything said, that is spoken, or a vote given by him in the parliament or any parliamentary committee thereof. The second limb prescribes that no person shall be liable before any court with respect to any publication or under any authority of either house of the parliament of any report, paper, vote or proceedings. Bribery is not rendered immune under Article 105 of clause 2 and the corresponding provision of Article 194 clause 2 of the Constitution, because a member engaging in bribery commits a crime which is not essential to casting of the vote or ability to decide how the vote should be cast. Now the same principle applies to bribery in connection with the speech in the House or also the committee, and this is what the Supreme Court said. So basically a two-test based with regard to the immunity that the MPs and the MLAs enjoyed. And if you like this points, don't forget to like, subscribe and share. And these are the important points that I wanted to highlight for this issue. And I shall see you in my next post. Until then, it's very happy learning.